All right. We're happy to have you here on the football law annual moot. It is the round of 8. My name is Leon Sanyange. I will be facilitating this session. It is the first session of the round of 8. With us, we have the Kenyatta University as the appellants and the Kampala International University as the respondents in the matter. We have a 3-man panel chaired by Mr. Francesco Macri, and also the members thereon, including Mr. Timothy Kaja and Mr. Ayomide Eribake. Once again, we're happy to have you in this session. And with those short remarks and introduction, I would like to officially hand the session to the chair, Mr. Francesco Macri.
Okay, thank you very much. It's a pleasure to be here. And first of all, happy to meet you, my colleague Timothy and Yumide. And so we can start this session. Of course, since this is a CAS hearing, I would ask you to the participants if they have any objection to the jurisdiction of this panel, and of course, just to introduce themselves to the audience. Thank you very much. We can start from the appellant.
Okay, thank you very much. My name is Mutaha Wanjiro.
My name is Maina Ahadi.
We are from Kenyatta University.
We do not.
Thank you. Any objection to the jurisdiction?
No, none.
We can move to the respondent.
Good afternoon, esteemed arbitrators. My name is Nelvama Christine, appealing with my co-counsel, Sefma George, on the behalf of the respondent. We do not have any question to the jurisdiction of this.
Thank you very much. And so we can start with the oral submission. We have you have 15 minutes, and there is 5 minutes for the rebuttal and sub-rebuttal. And of course, we can start from the appellant. Maybe that the panel can ask any question during this session, of course. But we will try to keep your submission until the end, just not to make you any difficult. Okay, we can start with the appellant.
Thank you very much. Greetings, my lords. Ahadi Maina and I, Mutaha Wanjiro, sit together today at the appellant's table, seeking justice for the appellant who has been condemned and heard. This case goes far beyond the lines of a football pitch to the very hearts of sports law and arbitral jurisprudence. This isn't about player and a club. It's about the kind of football jurisprudence we want to build. Is it one where justice matters or one where silence wins every day? With your kind permission, allow me to commence. I will start by categorizing our submissions. I will handle the first and fourth and third issue, that is jurisdiction, breach of contract, termination, and just cause. My co-counsel will handle the second and fourth issue, which is due process and notification and compensation assessment. Onto the issue of jurisdiction, I will divide the issue into 2 limbs. First is the jurisdiction of this court, CAS, and second, jurisdiction of FIFA DRC and the exclusive jurisdiction clause in the employment contract. Onto the first limb, the appellant wishes to submit that this court has appellate jurisdiction to hear and determine this matter according to Article R47 of the CAS Code, read together with Article 48 of the FIFA statute. Moving on to the second issue, it is the appellant's submission that FIFA DRC lacked jurisdiction to hear the matter in the first instance. My lords, jurisdiction is the live wire of every proceeding. A court without jurisdiction labors in vain in matters beyond its merit and does a disservice to the administration of justice. It is therefore erroneous for the respondent to seek redress from FIFA DRC, whereas there was an unequivocal agreement under the Article 12 of the contract, stating that any issue arising from the employment contract shall be heard by the NDRC. To go against Article 12 of the employment contract is in itself contrary to the principle of party autonomy and privity of contracts. The appellant wishes to recognize that Article 22 of the FIFA RSTP grants FIFA the power to hear international employment disputes. However, my lords, Article 22B provides an exemption to this rule where parties may opt in writing for such disputes to be decided by a national dispute resolution, the National Dispute Resolution Chamber. Also, Article 4 of the NDRC standard regulation grants the NDRC jurisdiction to hear disputes, contractual disputes affecting players and clubs. FIFA DRC ignored this clause, committing a procedural misstep, such as which was warned against by CAS in Raja Wild Athletic versus Lema Mabidi, CAS 2020 A7144. Moving on to the second issue, that is breach of contract, termination, and just cause. It is good law that employment contracts between a player and club cannot be terminated until its expiry of the contract or mutual agreement, or where there is just cause, as per Article 13 and 14 of the FIFA RSTP. My lords, in relation to this matter, the appellant wishes to point out 3 issues in support of their case. First, there was no contractual breach on the appellant's end. The respondent received his full monthly salary from December 2023 through to June 2024 without prejudice. The bonuses in question were subject to additional conditions not met by the respondent, therefore cannot be computed in the respondent's salary. Additionally, the respondent's claim for unpaid bonuses was an act of retaliation to justify their breach of performance of the contract. Second, the issue of the September salary 2024 deduction was a lawful disciplinary fine against the respondent for late resumption. Article 12 of the FIFA RSTP permits clubs to impose sanctions where the club regulations permit. Third, the respondent's unilateral termination of the contract lacked just cause. As held in CAS 2020 A7175, Al Arabi Sporting Club versus Joan Ignacio, a valid dismissal must be based on a formal club action, not informal remarks. The head coach's comment that the respondent was no longer needed was not communicated to the respondent. The respondent relied on hearsay to terminate the contract. The respondent's continuous absence is clear violation of the contract. Furthermore, my lords, Article 14 of the FIFA RSTP, read together with CAS 2017 A5003, Jerome Valk versus FIFA, where it was held that termination for just cause requires a fundamental breach, rendering continued employment unattainable. Mere communication indifference between the two parties, they cannot suffice to meet such high threshold. I wish to thank my lords for giving me this time, and with there being no questions, I wish to cede the floor to my co-counsel to adjudicate on the remaining issues.
Thank you very
Greetings
much.
and salutations. Greetings and salutations. My name is Maina Ahadi, appearing alongside my co-counsel Vince, and with the panel's discretion, I would like to adopt his introduction. And without further ado, I would like to dive into the 2 issues: due process titled The Voice Never Heard, and compensation assessment titled Redeeming the Skill. My lords, let us turn to the Dhaka breach, a decision rendered in silence against a party never heard. The FIFA DRC awarded 40 million to the respondent by default, but a judgment rendered without notice is not a judgment, it is a shadow. There was no service of process, no invitation to defend, no opportunity to plead, nothing but a mere dispatch into the void. And my lords, justice must never be carried out in whispers. We further rely on Samir Arab versus UEFA, where the tribunal reaffirmed that the right to be heard is a fundamental procedural guarantee, and failure to ensure adequate notification and opportunity to participate renders a decision unenforceable. Similarly, to further buttress our position, we rely on Galatasaray versus Igor Tudor, where the CAS declared procedural fairness is not optional, it is mandatory. Default awards without proper notification offend natural justice. Even under the FIFA procedural rules, Article 10 through 12, proper service is required to allow both parties to respond. And under NDR CSR, Article 8, alternative modes of communication are expressly permitted, yet none were attempted when the appellant CEO was hospitalized. Thus, FIFA's own framework stands on the same principle. A decision without hearing is no decision at all. My lords, allow me to draw your gaze to the very architecture of the FIFA administrative framework, the FIFA Connect. Power Stars FC is not a mystery club. It is registered, it is recognized, it is encoded into FIFA's digital DNA. Through FIFA Connect, the respondent and FIFA had direct visibility over our full identity, our official contact points, our registration number, our electronic footprint. And so we ask this tribunal, if a system exists that is designed precisely to ensure traceability and transparency, why was it ignored? Why did the FIFA DRC allow communication to falter on a single dormant email account when FIFA Connect itself would have lit the path? My lords, justice in football must not become a casualty of administrative laziness. Where technology has eliminated doubt, failure to communicate becomes a choice, not a mistake. This tribunal must consider that the procedural silence in this case was not due to absence of tools, but due to deliberate neglect. If FIFA Connect exists to connect, then this disconnection is a dereliction. Any ruling born of such flawed notice stands on legs of sand. My lords, a silent judgment is a hollow one. Even Hades granted Orpheus the right to speak. Shall FIFA DRC deny Power Stars FC the same? I will swiftly like to dive to the second issue, compensation assessment, redeeming the scale. And now we turn to the most staggering outcome, the award of 40 million naira. Pause with me. The respondent's entire 3-year salary would have amounted to 36 million, yet he was awarded more than the full contract value after barely 10 months of service. This is not compensation, this is enrichment. CAS jurisprudence is unwavering. In Sondojevsky Football AS versus FIFA and Double FC, it was reaffirmed that the methodology of compensation must be objective, rooted in the contract and reflective of real damages, not speculative figures. Here, the respondent sought no trial, no club, no contact. He simply sat back and let damages inflate into a windfall. The FIFA RSTP warns against this. Article 17.1 of the RSTP provides compensation shall be calculated with due consideration for the law of the country concerned, the specificity of sport, and objective criteria including remuneration due under the existing contract and the time remaining. To further buttress my position, I rely on Article 17.2 of the same RSTP, which provides that the party claiming compensation must take reasonable steps to mitigate its losses. Failure to do so shall be taken into account when assessing the amount of compensation. Thus, the award of 40 million naira not only exceeds the contractual ceiling, it ignores the player's duty to mitigate. It creates a dangerous precedent that breach can become bounty. My lords, equity abhors such enrichment.
Council,
Football law cannot be rewritten. Yes.
On the issue of the quantum of damages that you say,
Yes.
that is it that in all cases when we have a contractual value, that value cannot go any higher than what is in the contract? Is that your position?
No. My position is it was to show how inflated the quantum amount was, since he only acted for 10 months and he was awarded 40 million, which is higher than the amount he would have been awarded if he played for all the 3 years.
And yes, and that's my question. Yes. My question is that should we say that the valuation of the contract after 3 years is the ceiling for compensation? Nothing can go higher than that.
No.
So
but our position is the FIFA Dispute Resolution Chamber. It did not provide a formula of how it tabulated this amount. It merely gave us an imagined amount.
All right. The FIFA DRC is not here. The FIFA DRC is not here, unfortunately. So what formula do you want us to apply if we uphold your appeal?
we would like you to annul the amount. We would like you to annul the decision rendered by the FIFA Dispute Resolution Chamber.
That is clear.
And
my question
yes,
is, what formula, if you're faulting the formula of the FIFA DRC, what formula should we adopt?
What formula should we adopt? We do not take fault on the amount that should be awarded, because it is our position that we did not breach the contract.
That's not my question. My question is, if we are to find that an amount has to be awarded, what formula should we use to compute the amount if you're faulting the formula used by the DRC? That's my question.
Allow me to assist in that question. It is our position that the NDRC, in giving its judgment of the 40 million naira, did not provide a tabulation of how they had reached that judgment. It was not a reasoned judgment. They just gave a figure. They did not tell us how they arrived to the figure. So any competent court, also as you have said, what this court to give an award, an arbitral award, it would have to provide how its tabulations on how it has arrived at that award. That is what the DRC failed to do.
Are you saying that the DRC used the wrong formula and us we should go out there and look for any formula, but you're not giving us
they did not.
Formula
They,
we should use?
okay.
The FIFA DRC did not show us how they arrived at the 40 million naira.
That's fair enough. That's fair enough. And my question is, what formula do you want us to use? If you're faulting the one that was used earlier, what do you want us to use?
We do not fault the one that was used earlier. We would like them to give us the formula they used to arrive at that specific tabulation.
Council, if you don't guide the tribunal or the NDRC on how they should come to a sum, and they adopt what they deem fit, then you cannot fault them if you have no alternative, because at the end of the day, we have to deliver justice. So if you are saying that the earlier NDRC did not use the right formula, then you should have the right formula. If not, then you don't have a ground to fault whatever formula they use.
Okay. First, it is our assertion that the appellant is not in breach of the contract. Thus, we are not entitled to an award against us. However, was this court find the appellant in breach of a contract, it is up to them to provide an award, and that they have to show us how they have reached the award. It is not up to the appellant to provide the court with a marking scheme for the awards. Our assertion in this case is that the FIFA DRC, first they had the matter without us being included, and secondly, they gave an award without telling us how they arrived at the award. We are not challenging. We are challenging the award due to the lack of the reasoning. How did the court arrive at that award?
All right. Let me ask you this way: in previous cases, has either the Court of Arbitration for Sport or the FIFA Dispute Resolution Chamber used any award that is taken, any formula that is taken to be acceptable in tabulating the quantum of damages if they find that there was breach? Previously, has CAS or FIFA had any formulas that they have used consistently?
Mr. Arbitrator, if I may, the term formula here, we are referring to how the court arrived at their decision. We do not claim that there is a formula, maybe y is equals to mx squared, not a formula as such, a formula in the sense of how did they arrive at their decision. They tell us they calculated the costs at this rate, etc., etc. That is what we define as a formula here, not a specific formula or a constant formula that can be used by a court. It's how the FIFA DRC came to the arbitral amount of 40 million naira. That is what they have failed to show us. How did they reach that amount?
All right, fair enough. You can go to the other point.
I was just actually finishing, and so my lords, we close not in bitterness, but in belief that this tribunal, as the guardians of fairness in sport, will restore balance, that it will uphold contracts, enforce processes, and restrain excess. And with that, we come to a close, and we hope that the tribunal will listen to our case, and we do pray that the tribunal will set aside the decision rendered, declare the FIFA Dispute Resolution Chamber's judgment to be ultra petita, to reduce the compensation, to find that NDRC was the competent forum to adjudicate the dispute, and to hold that no sanction was warranted against the appellant under the applicable regulatory framework. Thank you.
Thank you, Counsel. I don't know if Ayomide has any other question, or Timothy as well.
Yes, if probably, I don't know if they can take it now, but I also wanted if they could address us on the dormant email. Where did the dormant email come from?
Okay, Mr. Arbitrator, thank you very much for the question. As per the facts of the case, we can see that the respondent, while filing the matter in the FIFA DRC, they relied on the email, on the CEO's email. However, the FIFA Connect provides alternative means in which service can be effected upon the club.
Before we go there, so
yes.
It was the CEO's email. Is
yes, yes.
The CEO to which party here?
To the Pastors FC, to the appellant.
Appellant's CEO.
The email was for your CEO.
Yeah.
Yes.
The email was for your CEO. All right, that's fair enough. Then the last question is on when you spoke about the whether it was fair to terminate the contract, and probably the sanctions that were applied before the termination. Can you walk us through those sanctions that were applied before a decision was made that termination is the best course of action?
Okay, thank you very much, Mr. Arbitrator. Thank you very much, Mr. Arbitrator. First, allow me to point out on the issue of notification. As we have submitted, the respondent, there was no, in the beginning, there was no communication from the coach to the respondent that he was not needed. The respondent relied on hearsay from the captain that he was not needed. First, he did not take any measures to confirm the truth of the statement. He just terminated the contract and went home. Secondly, when the CEO noted that the player was not coming, he texted him, he communicated to him asking of his whereabouts and why he had not come.
I just want you to go straight to the sanctions.
Yes.
Address me on what sanctions need to be applied before someone can go for termination. What sanctions can we apply before we go to termination? Directly that.
Well, we can impose disciplinary measures such as fines.
Yeah. Which?
Was a fine applied here?
Yes. And he was fined for his late resumption.
So
and then he decided to terminate the contract.
Is there a lesser sanction than a fine?
Well, is there a lesser sanction than a fine? Thank you very much. We find the appellant finds that a fine is a decent sanction for late resumption.
It's not my question. My question is there a lesser sanction than the fine?
It is the appellant's submission that fine is a decent. There's no less on. It's a decent.
It's not a question of decency. It's a question whether there are lesser sanctions that could come before a fine. That's my question.
Yes.
Which are those lesser sanctions?
A warning.
Was a warning applied here?
A warning was not applied here.
Why was it applied?
Although for his late resumption, when he decided not to show up, the CEO contacted him and asked for his whereabouts. So it was because we do accept that we did not give any warning, but
so
it was appropriate.
You concede that you went to a fine termination and then you skipped all the options for the lesser sanctions.
No. Mr. Arbitrator, allow me to bring it to your attention that it was not the appellant who terminated the contract, it was the respondent.
Yes, it was the respondent.
The appellant imposed fines upon the appellant, upon the respondent for late resumption. The respondent took no measures to maybe contact the club and discuss the fines or the reasons for his late resumptions. He just unilaterally decided to terminate the contract.
Yes.
So it is the respondent who is at fault for unilaterally terminating the contract. It is not the appellant.
Yes.
And also the termination.
What about on the part of the appellant of trying lesser means before going to the fine? What about that? Do you consider it?
Well, Mr. Arbitrator, let me, as I had said earlier, fines are the fines is a decent punishment for late resumption.
Yes.
One thing, it's an employment contract, and a player is supposed to be disciplined as per the club's regulation. So late resumption is an act of indiscipline and defiance to the club.
Fair enough. I only want you to narrow it down, whether you concede that you could have applied lesser sanctions before you went to the fine. That's all I want. Do you find that you should have done that, or you don't see the need to do the warning before you go for a fine?
Well, Mr. Arbitrator, I can say that no, fine is a decent punishment for them. There is no lesser one. They had defied the club by failing to.
All right, it's fair enough. It's fair enough. That's all for me.
Thank you.
Okay, thank you, Timothy. And just a very, very quick clarification from my side. You said in your prayers for relief that your position is that the decision of the RC was ultra petita. Can you clarify me this concept? Because from my point of view, you have a decision from the RC. You didn't contest anything in during the RC proceedings. So how can you define? How can you conclude that this decision was ultra petita? Because there is ultra petita in respect of something that has been requested or not. No? Thank you.
Thank you very much, Mr. Arbitrator. First of all, we would like to bring it to the attention of this court that during the proceedings in the DRC, we were not aware. We came to know of the existence of such after the end of the suit and the award had been granted. We were not accorded a fair hearing. That's one. Secondly, on the doctrine of ultra petita, it is more than requested. In relation to that, it is the appellant's submission that one, the FIFA DRC did not provide how it had come to its determination. And thus, if you look at it, the amount that the player could have got, would he have continued with the whole contract, is approximately 36 million. Yes, we can take this line of thought that that a court is entitled to provide damages and interest accruing. That's one way of looking at it. However, they did not provide us how they arrived at that amount, and that constitutes of unjust enrichment on the side of the respondent. It can be considered as a tactical approach by the respondent to terminate the contract, go to the FIFA DRC, get a judgment, get an arbitral award, not enjoin us as a party, then get an award and then enforce it. That is a tactical approach, because in the end, they tend to receive more than what they would have received would they have fulfilled the whole contract.
Yes, counsel, I understand, but you know that the player asked for a compensation, so there is nothing ultra petita, because when you ask for compensation, then it's a decision from the DRC, the amount that could be awarded to the player. So from my point of view, we can discuss of everything, of course, during a case proceeding, but there is nothing ultra petita, because I asked for compensation. So my request for compensation was from 1 to 10 million. Okay. So I don't know if you agree or if you can, but I can understand if you object to the compensation. But in my view, of course, I don't know my colleagues, there is nothing ultra because it's just a request for compensation, or not. Sorry.
Okay. Thank you very much. So
Thank you.
allow me to give you our line of thought when giving the doctrine of ultra petita. It is, we had looked at the amount the player would have got, would he have completed the whole contract, which is approximately 36 million. But the damages, the arbitral award given by the court, he received 40 million. So it was the appellant's argument that that is more than what he would have got or what he would have asked, would he have fulfilled the whole contract. That is where the logic of ultra petita was coming from. Yeah.
Okay, thank you very much, counsel. So we can move to the respondent, and let's start 15 minutes from now. Thank you.
Once again, good afternoon, esteemed arbitrators. For purposes of record, Christina Lubwama. We are appealing on the instructions of the respondent. At the heart of this dispute lies a fundamental question. Can a professional football player's rights to a fair treatment, contractual remuneration, and access to justice be disregarded by a club's maneuvers and procedural maneuvers or contractual breaches? This case is not about it is not only about contractual disagreement, it is about safeguarding the essential rights of a player in the global football community. From the outset of this dispute, the respondent sought only what every professional player is entitled to, which is the right to be paid in accordance with the contract, the right to clear and firm communication from his employer, the right to just disciplinary procedures, and right to seek redress before an impartial tribunal. When those rights were violated by the club, the facts are very clear. Despite his outstanding performance, the club went ahead and refused to pay his November 2023 salary and agreed bonuses, subjected him to unfair disciplinary sanctions and salary deductions, and left him without any recourse to his legitimate grievances. When this club failed to honor its obligations, the player exercised his rights by instituting a case before FIFA DRC. I will be submitting on the merits of the fact issue, and that is whether FIFA DRC was a competent forum to entertain the matter and compelled with the principles of natural justice and fairness in arbitrating this matter. This issue is going. I'm dividing this issue into 5 limbs of argument, and one is the default jurisdiction, decision on its jurisdiction, recognition of NDRC of NFF of Nigeria, definitely, preclusion of dispute on competency in appeal proceeding, and exclusivity in jurisdiction. Mr. Esteemed arbitrators, I'll be proceeding to submit on the merits of the issue in the first limb of argument, and that is the default jurisdiction. It is straight law that Article 22 and 23 read in tandem, and they grant FIFA DRC jurisdiction to entertain any matter of an international dimension. And Mr. Esteemed arbitrators, case Arbitral Award 4846/2016 provides that the jurisdiction of esteemed arbitrators, in this regard, FIFA DRC in the case of in CAS Arbitral Award 4846/2016, it was held that FIFA DRC had competent jurisdiction to entertain matters of an international dimension, and the internationality of matters is depending on the nationality and not on the nationality of the parties and not the nationality of the dispute. Ned Chikomeko is a citizen of Uganda, a registered citizen of Uganda, and Power Stars FC is a club in Nigeria. So the dispute is the nationality of the dispute is Nigeria, but however, we're considering the nationality of the parties. Ned Chikomeko being a Ugandan player and Power Stars being a Nigerian club, by virtue, this is a matter of an international dimension. Mr. Arbitrator, esteemed arbitrators, I'll be proceeding to the decision on its own jurisdiction. CAS 2023 Arbitral Award 969636 provides that in case of any dispute, any party that institutes a case first lays the forum, the ground for the forum. Ned Chikomeko went ahead and instituted a case before FIFA, DRC, and of course he laid a clear forum for this party, meaning that FIFA, DRC assumed jurisdiction by virtue. Mr. Arbitrator, the mere fact I'll be proceeding to submit on the issue of recognition of the NDRC of Nigeria. Mr. Arbitrators, for any NDRC to be recognized as an impartial tribunal or body to entertain any matter, it has to be fully recognized and it must comply with the principles of FIFA. However, and these principles being, it must be an independent tribunal, it must be impartial, it must be competent to adjudicate matters on its own. However, the appellants have failed to establish whether NDRC applied with the principles of the required principles of FIFA in order to entertain this matter. Mr. Esteemed arbitrators, I'll be proceeding to submit on the exclusivity in jurisdiction. The mere fact that there is an exclusive clause in the contract does not oust the inherent and legally provided jurisdiction of FIFA DRC in this matter. Mr. Arbitrator, esteemed arbitrators, when we are weighing the equality of arguments in regards to exclusivity of the clause, we are going to look at the influence of different parties. The fact that Ned Chikomeko was a Ugandan player and definitely the Power Stars FC was the club, of course his ideas were not brought on board. However, he had to just sign on what was put in place by Power Stars. He went ahead and signed on the contract, and of which in the contract there included an article that provided that in case of any dispute, NDRC was the only party, the only tribunal to adjudicate this matter. But however, an exclusive clause does not oust the inherent jurisdiction of FIFA DRC to entertain these matters, because FIFA DRC is labeling to protect the club's rights and all other, the players' rights and all other clubs' rights in regards to football. I therefore submit, Mr. Esteemed arbitrators, and if there is no questions for me, I would like to keep my remaining minutes for my co-counsel.
Thank you. Please go ahead.
Much obliged, esteemed arbitrators, and a good afternoon. I'm George Semfuma once again, and I'll be proceeding on the merits of issue 2, 3, 4, and subsequently make prayers for the respondent. Esteemed arbitrators, the issue 2 raises a question as to whether Ned's leave from the club did amount to absconding. It is a respondent's argument that his leave did not in any way amount to absconding of his contract. And I intend to be submitting on this issue under 2 limbs of argument. That is, actions out of good faith are ones that are justifiable and excusable under the law. And second, that the lack of intention on Ned's side to abscond. Esteemed arbitrators, it is further respondent's argument that when it comes to good faith, it is a broad legal understanding of the concept of honesty and acting with respect to each one's rights to a contract. Esteemed arbitrators, honesty being acting not in a deceitful manner, not in a manner that intends to mislead the other party that may seem inferior. In this case, Ned Chikomeko, who was provided with a standard contract which he signed. He did not participate in the collective bargaining or the negotiation in the collective bargaining during the drafting of the contract. Esteemed arbitrators, Ned's initial absence from the club stemmed from a communication, unauthoritative communication from a team head coach. Esteemed arbitrators, I would like to invite you to consider paragraph 28 of the definition clause of the FIFA RSTP. It defines and lays down the authority and the duties of a coach. A coach is an individual who has the authority, among others, to choose who continues to participate, who participates in the team's matches or in a match and the competition in general. We're talking about the Nigerian League, which is a competition, esteemed arbitrators. This is a coach who has such authority to decide who goes ahead to participate in the sporting actions of a club, of which Ned Chikomeko is a player of the same club, and it's his contractual obligation to participate in such actions. Esteemed arbitrators, the coach's communication, any reasonable person put in Ned's position would believe the coach's communication due to the authority that a coach carries over who goes ahead to participate in the club's sporting activities. Esteemed arbitrators, we humbly caution this honorable tribunal that this case follows a multitude of cases where players, talented players, have contracted with foreign clubs, and clubs have went ahead to detriment or to hurt these players' trust in the game of football. A clear example is Fahad Aziz Bayo. His contract was terminated mid-air due to a communication break for which he had no authority to establish an effective and clear communication. This led him to a detriment that he couldn't recover from till he sought justice. So we urge this honorable tribunal to dispense justice to the respondent. I'll proceed to limb 2 of my argument or submission. Esteemed arbitrators, CAS Arbitral Award 3813 of 2014 clearly states that in any dispute, intention of the parties must be considered. In this case, when Power Stars FC, the CEO went ahead to contact the CEO went ahead to contact the player with immediate effect boarded, and he left the country where he was residing for his holidays and went back to Nigeria for his contract to commence or to proceed. Esteemed arbitrators, I'll proceed to issue 3 of my submission, which is whether the termination was with just cause, and it is our verment that there was indeed a just cause. Esteemed arbitrators, just cause is defined in line with the good cause pursuant to, or as is stated in Article 337 of the Swiss Code of Obligations, and good cause to lawfully terminate an employment contract exists when the fundamental terms of a contract, of a contractual arrangement, are no longer respected by one of the parties. Furthermore, Article 8 goes ahead to assert of the same obligations that at any point where there is a difference or a contradiction, Article 21, at any point where there is a contradiction between the performance and the consideration, a party has a mandate to terminate such a contract. Furthermore, esteemed arbitrators, I'll proceed to submit on the just cause to terminate. Esteemed arbitrators, I'll use 4 sublimes of argument to submit on this issue, on this sublim, and that is the seriousness of the breach and whether bonuses are a material component of the contract, of the remuneration. Esteemed arbitrators, in principle, the breach is considered sufficiently serious when there are some objective circumstances that render it unreasonable to expect an employment relationship between the parties to continue, such as a serious breach of trust. The moment there is a serious breach of trust, esteemed arbitrators, the contractual obligations cease to exist and this must be effected. This was a position in Player A versus Club C, which is a FIFA DRC decision 1018-0471. Esteemed arbitrators, the same position was iterated in Article 14 bis, where it was stated that where a club unlawfully where a club unlawfully fails to pay the players' monthly salaries or remuneration for more than 2 months, such is deemed a breach of a contract that can ground unilateral termination. Esteemed arbitrators, CAS Arbitral Award 6889 of 2020 stated that the determinants of a serious breach are to be analyzed on the basis of the amount owed, which is, as stated by the appellant, 36 was a performance amount in total, the duration for non-payment, which is at the moment for a full season, esteemed arbitrators, and the failure to remedy after being put to fault, and whether, well, I'll proceed to whether the bonuses constitute a material component of the remuneration. And this was established in CAS Arbitral Award 5882 of 2018, where it was clearly stated, esteemed arbitrators, that for a bonus to be considered as a material component of a remuneration, it must first of all be contractually stated. It must be stated in the contract. Two, it must have a significant figure. And three, it must be based on the player's performance. Esteemed arbitrators, I'll proceed to the next limb, which is termination as last resort. This is established under Article 14b, where it says that the player must go ahead to notify, or the party aggrieved must go ahead to notify the other party of their grievances prior to the termination and give them 15 days. Esteemed arbitrators, this is what the player did, and he gave the club approximately 19 days and beyond to justify their actions. Esteemed arbitrators, we proceed to the unjustified salary deduction. Esteemed arbitrators, the player was not at any point invited to participate in the proceedings.
Counsel, sorry, but you have 1 minute left. So just to organize your submissions.
Okay, thank you, esteemed arbitrator. As I was saying, the player was not at any point invited to justify why he was not present at the time, and this defeats the whole essence of a salary deduction. And the club just unilaterally decided to deduct the players' sweetly earned salary. And esteemed arbitrators, the club intends to seek remedies from this honorable tribunal, but it did not. It breached the principle of clean hands, or the clean hands doctrine. It is seeking justice, yet it did not do justice, esteemed arbitrators. Esteemed arbitrators, the respondents respectively submit that the club materially breached the employment contract by failing to pay the bonuses, and we pray that the default judgment by the FIFA DRC be found valid and upheld, that the FIFA DRC had jurisdiction. FIFA relied or followed the right criteria of the parties' rights, and this tribunal dismisses this suit with costs. Much obliged.
Thank you very much, counsel. I ask to my colleague Ayumide or Timothy if there are any questions for the respondent.
Okay.
I don't know.
I think I have probably just one question, and my question would be that for the respondents, is your argument that salary deduction for 3 months warrants a termination of contracts?
Pardon me, esteemed arbitrator.
Yes, sir. I said that does the deduction of salaries for 3 months, does it warrant the termination of contract?
If I may ask, did I get your question right? That you're trying to ask whether the failure to pay for 3 months and beyond does warrant a deduction?
No. His salaries were deducted for 3 months consecutively with the non-payment of bonuses. But I am asking you that does the deduction of salaries for that 3 months, does it warrant the termination of contract?
Esteemed arbitrator, it does warrant termination, unilateral termination. It is valid just cause. Because the club had to fulfill its contractual obligations. However, it did not. And it went ahead to fail to pay the club, the player, for a period of over 3 months.
But then, non-payment is different from partial payments, don't you think?
Pardon me?
Non-payment of salaries is different from partial payments of salaries, don't you think?
Much obliged, esteemed arbitrator. It may, but it is our position, esteemed arbitrator, that this bonus constituted a part of the remuneration, and this is hardly earned remuneration, and it is intended to encourage the player to continue playing on or with a form. So this, if the player goes there to perform and in the due course is not given what he performed for, it goes ahead to demotivate, and it goes to the core of the contract. So this is a person who was promised compensation or bonuses, sorry, for any win on away and any win on home, which he went ahead to do. As a keeper, he went ahead to perform on form, and the club received the wins it wanted. But if this position is kept ongoing, esteemed arbitrator, every club is going to come up and it's going to sit or detriment the rights of a player, and in the due course say that the player sat on their own rights and we merely paid half, yet they did not justify the reason as to why they went ahead to pay in half.
Fair enough. It's okay. Thank you.
That's fine.
Timothy, any question? Or should I?
All right. I just have two questions. Number one, whether the absence of the player is deemed material breach in itself. His absence, was it, how material was it?
Pardon me, sir?
The absence of the player, can we deem that as material breach that does not also leave your hands clean, the player's hands clean, if you are indeed absent?
Esteemed arbitrator, the player was indeed absent, but his absence, as has been earlier on explained, is stemmed from unauthoritative communication. A communication from a coach, a head coach, as I've defined it, as it is defined in the FIFA RSTPs, the definition clause, paragraph 28, it is clear that a coach has the authority or the duty of choosing who goes ahead to participate in the club's match and subsequently the competition, or in general, the competition. This position, the Nigerian league itself, or the Division 1 league, is a competition for which NED has a contractual obligation to perform in, of which contractual obligation is on field, and the on-field participation is influenced by the head coach. He's the one who chooses who goes ahead to participate in the competition and in the match itself.
So are you arguing that the coach allowed him to leave? That's your argument?
And Timothy, sorry, if I can jump in the question, because it's I would go for that. I enjoying the question from Timothy, but do you think that the WhatsApp from the coach is an official communication of the club? It's your position that is an official it's an official communication.
We beg your pardon, esteemed arbitrator.
Sorry, can you hear me?
Yes.
Okay, so if I can add something to the question from Timothy, do you think that the WhatsApp, the message from the coach, is an official communication of the club? Can you understand? Can you support that this is an official communication, a legal communication?
Much obliged. Esteemed arbitrators, yes, we deem it an official communication pursuant to Article 33 of the Swiss Code of Obligation that talks about the scope of authority. In football, we are looking at, due to the fact that this contract was completed between the CEO Power Stars, but not the club itself, the CEO was acting as an agent of CEO of the club. And definitely, the player cannot go directly to the CEO, but instead the player goes through the captain, the coach, to the top. So when you look at the scope of authority, yes, a communication from the captain is deemed official, and the fact that the contract was completed via WhatsApp, that means that it is already deemed official because the work contract was completed via WhatsApp, which is recognized mean of communication in regards to to contract.
Okay, thank you.
All right.
Please,
yes, my last question, and I wanted to go to the lady. Has FIFA put up specific rules or regulations on how national NDRCs should be set up? You're muted.
I beg your pardon?
Has FIFA put up specific rules or regulations on how a national NDRC should be set up?
Yes. Yes, esteemed arbitrator.
Which are those? Can you help cite them?
The NDRC recognition standards. Of course, there includes the independent, like this tribunal must be independent. It must be impartial. It must be competent alone to deliver a judgment.
All right, that's all. Thank you.
You're welcome.
Thank you, Timothy. Thank you, Domino. And so we can go for the rebuttal and sub-rebuttal, and starting from the appellant, please. 5 minutes.
Thank you very much, Mr. Arbitrator. First, allow me to first raise one point of fact which the respondent may be felt to have missed. The communication between the coach and the captain was not, there was no direct communication between the coach and the player. The coach communicated with the captain. The captain thus informed the player of that the coach did not want him. The player relied on hearsay. That's a point of fact. The respondents alleged that there was a WhatsApp communication between the player and the coach. There's no such thing. On to our first issue on recognition of tribunal. The respondents allege that FIFA and DRC is not an appropriate means to be recognized. But however, there is the NDRC principles, National Dispute Resolution Chamber principles, and the NDRC standard regulations, which we have relied on to prove that NDRC is a competent authority. In the same, Article 4 of the same provides that NDRC is competent to hear employment disputes between a player and a club. Secondly, the respondents have relied on onto paragraph 9, page 9, paragraph 1.1 of their written submissions. The respondents seem to have agreed that there's the existence of a exclusive jurisdiction clause in the employment contract. However, they have failed to implement the same when it comes to the jurisdiction of the NDRC. Secondly, paragraph 10, page 10, paragraph 4.1, they claim that the right to choose forum is such that the first party to institute a suit is the one who choose the forum in which the suit will be instituted. However, that may be true. It is important for us to state that that is only true where the parties have not agreed on a sufficient forum. However, here, there was an exclusive jurisdiction clause of the FIFA NDRC. Another one, paragraph 11.1, the respondents claim that any arbitration, the respondents claim that any arbitral tribunal has power to decide on its jurisdiction. Then my question to the respondent is, why did they not first file the issue to the FIFA NDRC and seek its FIFA, yes, and seek its jurisdiction in the matter? They hastily went forward to the DRC rather than going to the DRC. They hastily went to the DRC rather than starting to the NDRC. And then a last issue is page 14, paragraph 21.1. That I've already mentioned on reliance on the captain's communication. Also, on our point of law, if my lords, the arbitrators may grant me this latitude, I have noticed that the respondents in their written submissions have relied on FIFA RSTP January 2026 edition, which does not exist. They have also relied on a case that is not in the CAS database, yes, which is CAS 2020 A6789. We wish that this court may take note of those two when giving its decision. Thank you.
Thank you, counsel. And then we go for the sub-rebuttal from the respondent.
Thank you, esteemed arbitrator. And I'll start off with the exclusive jurisdiction clause, esteemed arbitrator. Yes, the respondent does not at any point contend the existence of an exclusive jurisdiction clause. However, what we contend is whether such an NDRC is a competent one or was a competent one. And esteemed arbitrators, it is our humble submission that the appellants failed to sue a party that could answer some of the questions. Esteemed arbitrators, the parties, the appellant go ahead to question, why didn't we file with the NFF, National Dispute Resolution Chamber? However, it is our right, it is the players' right to apply to any such forum that they deem will give them the justice they deserve or they should get according to the law, the established law. Esteemed arbitrators, the question of whether why the FIFA DRC assumed jurisdiction is not ours to answer. Esteemed arbitrator, the question of due process in notification is not ours to answer, because we appear before you on the orders of Mr. Ned Chikomeko and not FIFA, as was not included as a party by the appellant. Esteemed arbitrator, we go to the compensation. The compensation, esteemed arbitrator, looks at the remainder amount of the contract. It goes ahead to look at the benefits that the player was getting from the club and damages incurred. Whether we must also consider whether the player went ahead to assume new employment that could mitigate the compensation. So FIFA considered all these factors and went ahead to adduce that first and foremost, Ned Chikomeko did not at any point seek new employment, but he remained unemployed and it was a detriment to him at a continuous basis. Esteemed arbitrator, the appellants claim the existence of a dormant email. However, esteemed arbitrator, it is the same email for which the appellants went ahead to receive the general judgment, and later on they requested for the grounds, but after receiving the communication about the judgment in general initially from the same email, because FIFA goes ahead to use that very email that has been put to its portal. Esteemed arbitrator, the appellants have failed to prove whether the email was official or unofficial. Esteemed arbitrator, it is our humble submission that it is not upon the respondent to establish an effective and clear communication between himself and the club, but it is the duty of the club to do so as a superior party to the contract. Esteemed arbitrator, I would like to proceed to the right to be heard. The appellants claim to have not been heard. However, this is after a period of 125 days minus the protected period as is established. This goes beyond the limit of justice. In other words, esteemed arbitrators, justice delayed is justice denied. Esteemed arbitrators, the contact, it's the appellant submitted about the player not contacting or inquiring about the salary deduction. However, the facts of this case guide us and say that upon return and upon payment of his September salary, the player went ahead to inquire why he received only 500,000 naira. And this defeats the appellant's claim of the player not contacting. I would use the floor to my co-counsel to rebut in the remaining minutes.
Most obliged.
Sorry, Councillor. Yes, 1 minute left. Yes, correct.
I'll basically rebut on the submission of the appellant against the assessment of damages. Their claim that the damages were wrongly assessed, and in that regard, it amounted to 40 million naira. But however, Article 17.2 provides that when assessing damages in regards to bleach, the refusal of the performance of the party in bleach repeatedly amounts to an aggravated circumstance. And in that regard, we will consider the residual monthly value of termination that will be given to the player, and then the future salary plus the expected monthly bonuses, and that all totaled to 40 million naira.
Much obliged, esteemed arbitrators. I will say our closing statement. Esteemed arbitrators, if this honorable tribunal goes ahead to establish a binding precedent that does not uphold the rights of a player, but instead supports a club that goes ahead to waive a player's right to payment for his duly earned salary, duly earned bonuses, for his skill, his talent, this is going to open a loophole of a number of cases where clubs are going to contract players and subsequently fail to pay or continuously pay in half, which is a detriment to a player. It is the appellant is on an expedition to evade justice, esteemed arbitrators. It subsequently agrees that it did not pay the players bonuses, which constitute the monthly remuneration. And this defeats the whole essence of justice and kills the trust of a contractual relationship. It's so submit, esteemed arbitrator.
Thank you very much, councils. And so we are at the end of this hearing, unless my colleague have any other question, or we can go for the closing moments. And before the closing of this hearing, I would ask to the parties if they are satisfied with the way this proceedings was conducted. Just say yes or no, starting from the appellant.
Yes, we are duly satisfied.
Thank you.
Yes.
Respondent.
Yes, we are duly satisfied.
Thank you very much. And so the hearing is closed, and I don't know if we can give, if we have time to give just a very brief feedback or not. I ask to the organizer. Should we go for a brief feedback or not?
Thank you very much. If only we can keep it within a very short period of time, as we have another session coming up in the next.
Okay.
Actually, no,
okay.
until the time of the next session. Yeah. So short feedback, and we'll appreciate that.
Very, very short. My congratulations, first of all, to both the teams, and just a tip for your future of counseling. If you will decide to proceed with the sports law, be prepared for the hearing. Just to follow your program. Let's say to follow your index, but do not make, let's say, some confusion. So you have your request for relief. My suggestion is to start from your request for relief and then go through the separate argument. So if you ask, let's say, for the annulment of the decision of the FIFA DRC, I'm telling to the appellant. If you go for that, be prepared just to clarify everything about why you want the annulment of the decision. And if you are objecting the jurisdiction of FIFA, well, you have to give us some basis on if you want us to annul the decision. And moving to the respondent, since you have let's say a jurisdiction clause, you have to be prepared to let's say to support the decision of the FIFA DRC in this case, and you have to be prepared to explain and support. I think I don't know if Timothy and Ayomide agree. The most valuable argument of your position, that is the absence of the player, because this is the point of this case, the absence of the player. Should we pay a player that was absent, that's absolutely absent? And this is a very key point for my, this is just a very brief suggestion. And keep the time, both the team just stay, just keep the time, because if you are, let's say, if you don't respect the time, be that the panel can have the impression that you are trying to give more submission because you are not sure that we understand your position. So this is to keep the time is very important from my point of view. And that's all for me. And I don't know if Timothy and Yomide want to add something, or we can close.
All right. Probably what I could add, of course, is to congratulate them that they have done well. Very impressive. I like the fact that even they had this volume of authorities, and they could also fact check the authorities that this one has given us an existing authority. That is very good. It's very good to be able to think on your feet and be able to respond in time, because in reality you don't have a lot of time, but if you can use the minimum time to do well, that is very, very impressive. What I could add is that every time you're driving an argument, it's not always about defeating the argument of the other person, especially if you want to overturn a decision. You must lead the panel to the alternative. You must lead them. Don't just leave things to them. But as long as you are now, that's where we stop at. These are people who are listening to your case. They're listening to your story. So don't leave them in the middle of the road. If you want to lead them away from something, take them directly where you want them to be. Even if you make a decision that, let's say you want probably want the first round of yours to deal with the entire appeal. Let's say if they're going to that probably the decision was erroneous. You should also imagine, what if they don't say that it's not erroneous? What if they uphold the decision? Could you find any other window? Because always in law, we don't, a win is not always a clear win. Let's say if your client, it's not that when the appeal is overturned, you've won. You could also win if, let's say, if the damages were about 40 million, by dragging it down to 10 million, you have also won. So you should leave all these avenues possible, so that if you don't get the big one, you get a smaller one, it still remains a win. But other than that, I would also like to comment and tell you that you've been very impressive for the day. Thank you very much.
Okay, so we can close the hearing. Thank you very much again for being here, and thank you to the organizer, of course.
Thank you very much. I'm very, very excited about how the participants have gone through this. It's one of those nip and tuck kind of battles. Thank you very much, University of Kenyatta and the Kampala International University. Of course, the results shall be shared once the whole round is fully complete. I have another session with Mr. Timothy Kaja and Mr. Ayomide Aribake. I beg that we move forward to the next teams for the competition. Once again, I wish you all the best in your next endeavors. Thank you.
Thank you very much. Bye-bye.
Bye.